a good word. Let's look up hubris. It reflects the hubris that as long as the money was going through the pipeline, these companies didn't really have to make sure the documents were in order, said Kathleen C. Engel, Dean for Intellectual Life at Suffolk University Law School, and an expert in mortgage law. Suddenly they have a lot at stake, and playing fast and loose is going to be more costly than it was in the past. I like it. And playing fast and loose. I think that describes it more than anything else. Playing fast and loose. That's the word. Thank you, Kathleen C. Engel, Dean for Intellectual Life at Suffolk University Law School. Attorneys general in at least 6 states, including Massachusetts, Iowa, Florida, and Illinois, are investigating improper foreclosure practices. Last week, Jennifer Brunner, the Secretary of State in Ohio, referred examples of what her office considers possible notary abuse by Chase Home Mortgage to federal prosecutors for investigation. Signatures. The implications are not yet clear for borrowers who have been evicted from their homes as a result of improper filings by the banks. Improper filings. But legal experts say that courts may impose sanctions on lenders or their representatives, or may force banks to pay borrowers legal costs in these cases. Ooh, it's gonna be, yes indeed. There's some people got to be worried about this. Judges may dismiss the foreclosures altogether. Judges may dismiss the foreclosures altogether. That's what I think is going to happen, because judges are hopelessly liberal, really. They will represent the people at all times. My niece, Joanne, who is a lawyer and a teacher at the Sorbonne in France, says that the judges always go in favor of the small person in these cases. Oh, goody. Judges may dismiss the foreclosures altogether, barring lenders from refiling and awarding the home to the borrower. Oh, I get it. Judges may dismiss the foreclosures altogether, borrowing lenders from refiling and awarding the home to the borrower, back to the person who defaulted on it. Oh, that's so awful. That would create a loss for the lender or investor holding the note underlying the property. Almost certainly, lawyers say, lawsuits on behalf of borrowers will multiply. This is gonna be juicy. I knew this was going to happen when I read about it a year ago. I wondered what was going to happen. I mean, the house right next door to me back here was just auctioned off because the guy who owned it didn't pay his mortgage. He had a huge mortgage on it, far more than it was worth, and walked away from it. And the bank somebody just auctioned it off. And I expect to see my old neighbor back in that house. I really do. Is what I think. In Florida, problems with foreclosure cases are especially acute. A recent example of foreclosure cases in the 12th Judicial Circuit of Florida showed that 20% of those set for summary judgment involved deficient documents, according to Chief Judge Lee E. Haworth. Deficient documents. Can you say deficient documents? Deficient documents? We have sent repeated notices to law firms saying you are not following the rules, and if you don't clean up your act, we are going to impose sanctions on you, Mr. Haworth said in an interview. They say, we'll fix it. But they don't fix it. And the judges know really a lot more about foreclosure law than the people in the law firms, because they're not really interested in this stuff. You don't make money at this. As a result, Mr. Haworth said, on September 17th, Harry Rapkin, a judge overseeing foreclosures in the district, dismissed 61 foreclosure cases. 61! The plaintiffs can refile, but they need to pay new filing fees, Mr. Haworth said. The plaintiffs, the banks. The Byzantine mortgage securitization process. Byzantine? We'll have to look that up. And I am informed it's Byzantine and not Byzantine.
For God's sake.
The New York Times forces you to look words up. That's not good. The Byzantine, I don't know how they say it.
Byzantine.
The Byzantine mortgage securitization process that helped inflate the housing bubble allowed home loans to change hands so many times before they were eventually pooled and sold to investors that it is now extremely difficult to track exactly which lenders have claims to a home. Let me read this because this is the important paragraph. The Byzantine mortgage securitization process that helped inflate the housing bubble allowed home loans to change hands so many times before they were eventually pooled and sold to investors that it is now extremely difficult to track exactly which lenders have claims to a home. Ba-boom. Many lenders or loan servicers that begin the foreclosure process after a borrower defaults do not produce the documentation proving that they have the legal right to foreclosure, known as standing. They just foreclose. They don't need the papers. They know they're in trouble. Somebody said, foreclose on that house. We'll prove who owns it later. We don't own it anymore, but we got to get some money for it. Matter of fact, it seemed like the banks would stand to, the original bank would say, I'm going to foreclose. Because here's a chance to make some money. Here's a chance to own the house. Even though they don't own the loan anymore, they can claim they own the house. They can sell the house, put the money in the bank, and see how much of it they have to give away. That seems like a pretty good business. As a substitute, the banks usually present affidavits attesting to ownership of the note signed by an employee of a legal services firm acting as an agent for the lender or loan servicer. Such affidavits allow foreclosures to proceed, but because they are often dubiously prepared, many questions have arisen about their validity. Oh, that's what I thought. I like that. I have to read that too. We have to think about this. As a substitute, the banks usually present affidavits attesting to ownership of the note signed by an employee of a legal services firm acting as an agent for the lender or the loan servicer. Such affidavits allow foreclosures to proceed, but because they are often dubiously prepared, many questions have arisen about their validity. In other words, do you really represent the person who owns this? Are you really involved in ownership? Are you just jumping in like some legal firm and selling this house and claiming this house is yours? Although lawyers for troubled borrowers have contended for years that banks in many cases have not properly documented their rights to foreclosure, the issue erupted in mid-September when GMAC, General Motors Acceptance Corporation, said it was halting foreclosure proceedings in 23 states because of problems with its legal practices. General Motors Acceptance Corporation decided to do it on its own. Well, got to give them credit. The move by GMAC followed testimony by an employee who signed affidavits for the lender for GMAC. He said that he executed 400 of them each day without reading them or verifying that the information in them was correct. He just signed the things. Yes, yes, yes. Here. I don't know who owns what. Just get out of here. J.P. Morgan Chase and Bank of America followed with similar announcements. I'm afraid we don't really know who owns what. But these three large lenders are not the only companies employing people who have failed to verify crucial aspects of a foreclosure case, court documents show. I want you to see this one. This is Jennifer Bruner. Secretary of State of Ohio, who has highlighted examples of what her office considers possible notary abuse. And she should get her testimony notarized by 7 different people. But these three large lenders, J.P. Morgan, Chase, and GMAC, are not the only companies employing people who have failed to verify crucial aspects of a foreclosure case, court documents show. Last May, Herman John Kennedy, a loan administration manager in the default document group of Wells Fargo Mortgage, testified to lawyers representing a troubled borrower that he typically signed 50 to 150 foreclosure documents a day. 50 to 150. In that case, in King County Superior Court in Seattle, He also stated that he did not independently verify the information to which he was attesting. Oh, no. Tell me no. But that's true. He didn't. I'm telling you, I'm shocked. I'm shocked. I'm shocked and disappointed. Wells Fargo did not respond to requests for comment. Mr. Fargo, could you tell us what you think about this? You have nothing to say? In other cases, judges are finding that banks' claims of standing in a foreclosure case can conflict with other evidence. Standing means, I guess, that you're the guy who really deserves to get the money, who really is the guy. He stated back here earlier something about standing. Oh, proving that they have the legal right to foreclosure. The legal right to foreclosure is known as, quote, standing. In other cases, judges are finding that banks' claims of standing in a foreclosure case can conflict with other evidence. I know it, I'm sitting here reading the paper, having fun, and I should be working this week on my music. I've got to work this week on my music, and I'm gonna. As soon as I finish this today, which is just hopelessly important to me, I'm going to really get to work on my music. Maybe I'll tape it. That's what I'll do. I'm going to videotape most of my work on my own music, so you'll see I actually did it. Last Thursday, Paul F. Isaacs, a judge in Bourbon County Circuit Court in Kentucky. Bourbon County in Kentucky. That makes sense. In Bourbon County Circuit Court in Kentucky, reversed a ruling he had made in August giving Bank of New York Mellon the right to foreclose on a couple's home. He reversed it. According to court filings, Mr. Isaacs, the judge, had relied on the bank's documentation that it said showed it held the note underlying the property of a trust. But after the borrowers supplied evidence indicating that the note may in fact reside in a different trust, the judge reversed himself. The court will revisit the matter soon. Well, right. Because the people who sold him, the bank that sold him the mortgage, or gave him the mortgage, sold the mortgage and gave the papers to somebody else. Somebody else has to be doing all this filing. But somebody else is not interested in doing all the filing. They've run off with the money. They made their sales. They don't care. That's why these foreclosures are not going to happen. Because the people who got the money don't care. They don't care. They got their money. They got their commissions. They don't care. They're going nowhere. And this is the judge's little way of saying, if you don't obey the law, it will come back and get you. We passed these laws for reasons. We meant well when we passed the laws, and we mean well now when we're enforcing them. And even though the banks are hungry for their money, they're not. I mean, sure, the banks are having trouble with each other. They're all suing each other, sure, for the commissions, whatever. They're going to say the bank number 3 bought the mortgage from bank number 2 and gave bank number 2 a commission for it. Well, bank number 3 is now suing bank number 2 for the commission, and everybody's got to prove that bank number,